Hi, everybody. We're just going to give it a minute or two for everybody to come in, let the audios and the videos catch up with people as they're entering. It's nice to see some familiar names though. Hello, everybody. And still see people joining. So again, we'll just give it a couple more seconds, another minute or so. This seems to be slowing down a little bit now. So what I might do is go ahead and get started, and then people can join in as they come along. But well, first of all, hello, everybody. We'll go ahead and get started. Welcome to the Centre for Child Protection's Critical Conversations in Child Protection webinar series, season 2. It's quite exciting to say that this is our season 2 now. Last year, of course, was our season 1. Now, the objective of this series is to promote learning from the latest research, practice knowledge, theory, and lived experiences around safeguarding children and young people. It's for multi-professional groups of child protection professionals, including health, education, police, social work, third sector organizations, and more. Now, we aim at the Centre to try and get to the heart of child protection training using innovative ideas, as can be seen in our multi-award-winning public impact and engagement and research portfolio. Within that, we offer 3 key things. We offer continuing professional development training sessions using interactive and engaging child protection simulations. And this is looking at developing an understanding of exploitation, radicalization of children, as well as neglect, courtroom skills, training, understanding around sexual abuse, and more. We also deliver a postgraduate program in advanced child protection. This includes a master's, a postgraduate diploma, certificate, standalone modules, and a PhD, which are for multidisciplinary child protection professionals again. Now, this part-time and distance learning program is brilliant for many of our students who work full-time. And of course, distance doesn't matter. We have people all across the nation as well as international undertaking RMA. And we are recruiting now, and the closing date for applications is the 1st of December for our January 2024 start. And finally, looking at the Centre for Child Protection, I wanted to let you know about our MOOC, or Massive Open Online Course. This is focused on communication skills with working with vulnerable children. This is free and it starts on the 6th of November. So if you're interested, I would suggest you register now and sign up for that. I'll put a link for all of these things in the chat in just a minute if you want to know more. Now, before I introduce the very main event, a few housekeeping notes. Please be aware that we are recording this session for a time-limited public distribution. Also, you'll have noticed that your videos and microphones are disabled for a few reasons, but briefly, this is just to ensure an easy-to-hear, smooth, GDPR-sensitive experience for everybody. The chat feature is enabled, though, and this is to encourage you to have discussions with each other. And we would really want to encourage you to ask questions of India, who will be speaking in a minute, as well as networking with each other. But just a quick few notes about it. First, chat responsibly, respectfully. Chat is not recorded, so you're welcome to chat away as freely as you like in that sense, and not worry about it coming on the internet later. Now, India won't be able to read the responses in the chat and the questions, but I and some of my colleagues will be keeping an eye on chat, and so we will be able to answer non-specialist questions, and we'll be able to pull out key questions for India, and we'll ask her these questions in about the last 10-15 minutes of the webinar. We're going to try to get to all questions as much as we possibly can, but if we run out of time and there's anything urgent, please can you contact us separately? And finally, the big question is, will PowerPoint slides be shared? And yes, they will. We'll pop them on our internet, on the Critical Conversations webpage, usually within about a week or 2 of the webinar. All right, finally, please join us on social media. You can tweet about the event following @UniKentCCP or #CriticalConversationCP. Now, without any further ado, let's get ready for the main reason we're all attending today. India Hughes. India is an assistant lecturer and a PhD student at the University of Kent. She completed her Bachelor of Laws in the Kent Law School and went to work as a legal assistant in child protection before returning to Kent Law School as a coordinator. India was then awarded a SENS 3+1 studentship to complete her MA in social research methods and her PhD in socio-legal studies, researching the use of Section 20 agreements in child protection, which is why we're here, to learn how that's going. So I'm thrilled to be introducing India, and I'm really looking forward to her presentation today. I'm going to pass it over to you now, India.
Thank you, Tracy, and thanks everyone for coming. I hope you enjoy the talk today, and I'll just get straight into it. So I'm going to be talking about the law and practice of Section 20 Children Act 1989. And to give you an overview just briefly of what I'm going to be covering, I'm going to start off with explaining what Section 20 is and talking about the context of it within kind of child protection as a whole, and something about the intention behind it, as well as some of the positives and the problems with its use in practice. I will briefly explain my research, but as Tracy said, it is something that I'm continuing with. It's a work in progress, so I'm able to give you some of my findings, but not all of them yet. So bear with me on that. And the findings that I am going to go into a bit more detail on are my case law analysis. So I'll get to that, and that will hopefully be the kind of really interesting stuff. And then I'll wrap up with a brief kind of summary of where Section 20 sits now and what the situation is, before opening for questions. So given this is a child protection series, I'm sure this is probably old news to a lot of people, but it's important to situate Section 20 within the wider Children Act, and also specifically the tools in which children are able to enter the care system. So since the Children Act 1989 was brought into force, there are now 3 ways in which children can become looked after by the local authority. The most kind of well-known is by court order. So there's various different orders available within the Act, but they all have to be granted by a judge in order for the local authority to have that compulsory power to remove children. There's also police protection powers. These are specifically for the police and in kind of emergency safety situations, and they are limited as well to 72 hours. And then finally, why we're here today, there is Section 20, which allows agreement with those with parental responsibility to for the local authority to accommodate the child. And this is the context, and particularly how it was phrased in this Nottingham City Council case, in which Section 20 is kind of situated and was made in the Act, is that social workers and local authorities, it's an either-or situation. They can either get an order from a court or an agreement with the parents, and aside from that, there is no power to remove children. So then, looking more specifically at what Section 20 is and what it specifically says, it's situated in the kind of partnership, children in need type area of the Act, and it allows social workers to accommodate children where there might be no person with parental responsibility, they may be lost or abandoned, and the most kind of relevant one for my research is whether when the parent or person who has been caring for them is prevented, whether or not permanently and for whatever reason, from providing them with suitable accommodation or care. So this kind of gives a power or a duty to social workers to accommodate, but this can only happen as long as no person with parental responsibility who is willing and able to accommodate the child objects. So that's a very important caveat, and that's where we get this kind of agreement idea. And also importantly is, even once that has been agreed to, the parent or person with parental responsibility can at any time remove the child and effectively withdraw their consent. So Section 20 was made for various reasons, and it was definitely designed to be quite flexible and to be used in quite a few different scenarios. So some of the kind of most obvious or well-known things that it might be used for are things like short breaks where there might be illness or disability in the family, unaccompanied asylum-seeking children who are specifically mentioned in the section actually, as well 16 and 17-year-olds who can actually make the agreement themselves. It does not have to be someone with parental responsibility. So if these older children might be homeless or experiencing family breakdown, they're able to get accommodation without having to go through the kind of rigmarole of court. And then it was also designed for some safeguarding situations where the local authority is working in partnership with the family as kind of a family support tool. And at this point, I think it's really important to acknowledge just how common Section 20 is and how frequently it is used. So currently, and for the last few years, it has been the route of entry for about half of children who are becoming looked after by the local authority in England and Wales. So it's used in almost half, or it is specifically half of instances of children becoming looked after. And that's actually a reduction from around 2015, where it was up to 3/5 of children coming into care. So it's a very frequently used tool in child protection and children's services. So let's look into why Section 20 might be used or might be preferable to a court application. So to begin with, I've phrased it as kind of severity and cooperation. Specifically, what I mean here is, in some cases where there is some cooperation and there's some partnership, and maybe the concerns with the family are not too extreme, a court order might not feel necessary. It might not be the best way of working with that family. And Section 20 can allow for a kind of temporary break for those involved in the situation. It might allow for social workers to do some really worthwhile work with the family, do some assessments. It may allow the family to get a bit of space and make the improvements that they need to make, and hopefully mean that the family can be reunited and no kind of further intervention be necessary after a while. So that's kind of the best case scenario. Also, time is an important factor. So Section 20 allows, like I've just said, it allows some time for the family to do some work, for social workers to work with them. But it also can allow time for things like assessments and decision making. It may allow more time to kind of gather evidence and build more of a case that will be more effective if the case does go to court. It also allows families a bit more time to show progress and make the changes. And this is particularly important on both sides because care applications have this 26-week time limit. So once that clock starts ticking, there's only so much that can be done during that time. And also just the process of making an agreement is particularly quick. Obviously the court process, even if you are going for an emergency order, it takes time. And if the family are cooperating and it is a time sensitive issue to get the children into accommodation, then making an agreement is a much quicker way to do that. Money might also be a factor here, because care applications cost a huge amount of money, and we know that public services are not, rolling in it, and care proceedings can take up a huge amount of the budget. So if they are able to be avoided where possible, that can really help free up money to be spent on other things. And risk is a factor, because court orders are not guaranteed. Time and money can be spent on a case that ends up not being granted by the judge. And the local authorities' concerns don't just go away. So they're then kind of back to square one with the same concerns with the family, but not much that they are able to do at that point. So this all sounds really good, but obviously there's must be something the problem if I'm spending my time researching it. So there's the issue that Section 20 operates in what could be called the shadow of the law. So it is a legal provision, it's in a statute, but in general it is used without any judicial scrutiny. So there's not a judge overseeing what's going on. And it's often also without legal advice, either on one or both sides of social worker and family. Families are only allowed to claim legal aid if the public law outline process has started. So for those who don't know, this means if the local authority has notified them that they are considering care proceedings. So if that hasn't happened, then legal aid is not automatically available, just because Section 20 is kind of happening or being used. And social workers similarly don't always have to get legal advice. I think, as far as I'm aware, it differs between local authorities. In some cases, there are policies where social workers must gain legal advice either before or shortly after a Section 20 agreement is made. But in some local authorities, it's only necessary if there's kind of a problem or question. So there's not always legal advice even on that side. There's also an inherent power imbalance there. We've got social workers who are, they're state actors. They have a kind of a feeling of authority and some power to the general public and to families in particular. And so this then kind of brings up a question about when an agreement is being made, is it always okay? Is it always something that we can really describe as voluntary? And that's something that can kind of be dug into a bit more. Section 20 also offers not a huge amount of legal security or permanence to the child. I should note that my research particularly focuses on the agreements being made between the social workers and the adults in the family. So I am aware that there's kind of a lack of discussion of the child throughout my research, because it does focus more on the adults. But it is still important to acknowledge that this is something that really affects the child, and because there is that withdrawal of consent caveat there is always a chance that a child can be removed from this accommodation. So there's a lack of security there. And also because Section 20 generally isn't used or generally isn't kind of thought of as the long-term plan or the permanent plan for the child, it may kind of cause things to become delayed and there be then a lack of permanence and planning for the child. And these are just some of the things that have come up in the case law where there have been some instances of misuse and misinterpretation. And so I'm going to go into a bit more detail and some real life examples of those in a moment. So before I get into the case law, I'll just tell you a little bit about what my research looks at and what I'm doing. So Section 20 is actually very under-researched and underreported as well. So within academia, there's not been a lot written or researched about it, and there's not a huge amount known outside of social work practice about how it's really functioning. And even within practice, it's difficult to know how it's being used in other local authorities, even if social workers within one, they know how they're using it, they may not know how other people across the country are. And so my research is looking at how law and social work interact in the use of Section 20. And I'm particularly interested in the kind of power relations there between state actors and families. So for my data, so far I've analysed the case law. So I found around 40 reported court cases. And these are cases that have come to court and either been appealed, so have gone to higher courts, or have been particularly extreme or technical or problematic, so they may have already gone to a higher court. So I will be discussing those findings shortly, but it is really important to remember that these are the very extreme examples, so they can't be representative of how Section 20 is being used every day and in every instance. But they do provide some really good empirical evidence of the sorts of things that can go wrong and can be a problem within Section 20's use. On top of this, I'm also going to be analysing the responses from some FOI requests that I've sent out to all children's services departments in England. And I requested policy and guidance documents on Section 20 and any kind of template agreements or information that they give out to their service users as well. So I've sent that to around 150 children's services departments in England, and I've had nearly all responses. So I will soon be delving into the delights of data analysis on those. But unfortunately, I can't give you any findings from that yet. However, I did do a much smaller version of this study for my MA thesis, and that brought up some really interesting results and some quite wide discrepancy between how different councils were dealing with that guidance and the different documents that they use as well. So I am excited to see the types of things that come up in the bigger study, because there were some interesting results even from the very small one that I've done already. So for now then, I'm going to discuss my my case law findings and give you some of the themes and kind of lessons that can be drawn out from those. So to begin with, the case law has developed over the years, so it's important to get a bit of an idea on how things have changed and how it has worked along with practice. So we know that Section 20 came in the 1989 Act, but cases didn't really start to come to court, or at least at the higher courts, until 2008. And that's when we started to see some instances of misuse or misinterpretation of the section in the courts. And this really peaked between the years of 2012 and 2016, particularly in 2015, where there were a high number of cases. And this really seems to mirror what we know about the trends in the child protection system around that time as well. So we know that the use of Section 20, as we talked about earlier with the statistics, was at its highest at around 2015. And we also know that due to things like, the baby P scandal and austerity, the ethos in the child protection system was a bit more strict, a bit more risk averse around that time. And Section 20 and its cases have definitely kind of gone in line with those trends. And it's also really interesting to see what was going on around that time with between judges and local authorities on this topic, because a lot of these cases really showed an ongoing kind of frustration and concern from judges, and there were more and more warnings being made and guidance being given in judgments. And one case that this really came to head with was Re N in 2015. And those who have worked in practice may know this case. It was quite a well-known case at the time. And in this case, the president of the family court, President Mumby, sent a very strongly worded message to local authorities that misuse of Section 20 would not be tolerated and that judges were really going to crack down on it. And there were also some cases around that time where local authorities were fined quite heavily for some human rights findings to do with Section 20 as well. And so this had a real impact on practice, and Section 20's use definitely slowed down a fair bit, and it seemed to also become more cautious as well. And there's also evidence that a lot of local authorities undertook a kind of clearing or review of their existing Section 20 arrangements. So they may have looked at all children who are currently accommodated under Section 20 and issued some court proceedings where they felt necessary, maybe reaffirmed consent with families, and potentially updated their policies on its use. And then Section 20 finally reached the Supreme Court in Williams and Hackney in 2018. And that's a case that I will discuss a little bit more in my themes and findings now. Okay, so when analysing the cases, the first or the most common topic that really stood out in almost all cases, to be honest, was the issue of delay or long-term accommodation under Section 20. And this brings up various different concerns. So to begin with, as I've already discussed, the uncertainty for children is something that was quite commonly an issue here. And in this Kent case, it was really quite stark, and this is the one that probably stood out most, where a 12-year-old girl, she had been under Section 20 accommodation for 4.5 years, and she'd moved around 7 different placements. And the evidence in the case was that she was very aware of the fact that her mother did have this power to remove her from accommodation at any time. And so that really stopped her from settling into any foster family and any placement that she was in, and may well have contributed to the fact that she had been moved quite so often because she had not been able to kind of feel at home. There's also the issue of delay in assessments. So in Re-P, a very young child, I think a toddler at the time, was accommodated for 2.5 years. And during that time, not a lot was done to assess the family, to support or work with the parents. And the concerns within that family were fairly low level. There weren't anything particularly extreme. And eventually the work was done with the parents, and the child was allowed to return home, and everything ended quite well. However, the judge said that he had serious concerns that the time in care may well have even been more harmful than if the child had just stayed at home, because of all of these delays, it meant that it went on for so much longer than it needed to, and that it was kind of seen as a way to park the child and then not rush into doing the assessments and things, because the child was seen as safe at that point, so it wasn't so urgent. And then another issue that is obviously that I think has been one of the talking points around Section 20 is this idea of long-term drift. So there's two cases here, the Herefordshire case and the Worcestershire case. And in both of these cases, there were children who had been in Section 20 accommodation for 8 to 9 years. And these situations had really left the children, the birth families, and the foster carers in limbo, because no one really knew what was going to happen, whether the child was going to return home, whether they were going to be staying long term with foster carers. Foster carers didn't have any parental responsibility for that time. So there were some issues for basically everyone involved there that never really got resolved until the cases finally went to court. And then during often the accommodation, and this often tends to happen, I think, in the longer term cases as well, there can be times when parents choose to withdraw that consent. And as we know, that is specifically allowed for in the Act. But this is one of the concerns that President Mumby brought up specifically in Re N. And there were some cases such as this one, Re W, where this had definitely been found to have been unlawfully refused, essentially. So in this case, a mother eventually had to actually make a private law application for what was called a residence order, but would now be called a child arrangements order, to request her children, or request for the judge to order the children to return home, because the local authority had refused her requests for their return. And in this case, Mumby used some very strong wording and said that the local authority had been sidestepping due process in doing this, and had treated Section 20 as backdoor care proceedings. So some really strong accusations there. However, in Williams and Hackney, so that's our Supreme Court case, and the Supreme Court case kind of overrules the other cases that have gone before it. So if it disagrees with any, then the Supreme Court case is the one that you listen to. So in Williams and Hackney, Lady Hale, who gave the judgment, was very clear that the withdrawal of consent or a request for return had to be unequivocal. That was the word that she used. But this was quite confusing, because in that case, the parents had actually attended the council's offices. They'd requested the return of their children, and then they'd later gone to a solicitor who had sent a letter giving formal notice of the father's intention to withdraw consent in 10 days' time. And this was held to not be an unequivocal request for return, which I personally find a bit confusing. I don't really know, how much more equivocal you can get, but this was held to be not enough. So it was not an unlawful refusal of the request when it took another couple of months for the children to go home. And I think it is arguable that any request, even if it's not really, really clear, should probably cause a prudent local authority to review that consent, right? And to consider whether it's necessary to issue proceedings, to check in with the parents and discuss that with them. So here we have a bit of a grey area, a bit somewhere where the law doesn't seem to be completely clear how the courts would deal with various different situations involving withdrawal of consent. So on the topic of consent then, in the case law, there's various different issues that can come up when considering consent when making a Section 20 agreement. And I'm going to talk about a few different questions almost that can be useful, I think, and that the case law can demonstrate are important to consider when making that agreement with parents. So to begin with is this idea of whether it really is voluntary. And I find it interesting to think of this as another question, which is, what is the risk of refusal? So obviously it's probably kind of common sense that in a lot of people's, the back of at least of people's minds, when dealing with child protection and social services, and when you're in that situation, that if you don't cooperate and if things don't go well, this could end up in care proceedings. That's probably what most people kind of are aware of. However, I'm in no way saying that that makes all agreements involuntary at that time. However, in this respect, there have been cases, and in the case law, there has been instances where judges have believed, or there has been evidence that social workers have used it as more explicitly as a kind of a threat to say, if you don't agree to this, we're going to take you to court. And that's something that judges have not been favourable about and have not said is appropriate at all. And then there's also this fear of being seen as uncooperative. So in this Medway case, particularly the judge warned here that in cases of suspected non-accidental injury, so this case was about a suspected shaking of a very young baby. He said that in that type of case, parents are not going to want to seem uncooperative. They are likely to be doing all they can to kind of prove themselves to be very agreeable and not to be causing problems, and to be wanting to do whatever they can to help. So he expressed some concerns that it may never really be appropriate in those situations. And there's also a fear, I think, of the evidence of this non-compliance or this uncooperativeness then being used in court. So in Re W, this was actually included in the wording of the written agreement that was used, and it actually said that this could be used in court as evidence if needed. And here again, the judge was very critical of this, and said that it was almost kind of silly how they had admitted to the kind of duress of the agreement within the wording of it itself. And then finally, specifically in cases of mother and baby placements, there might be this fear of being separated. So mother and baby placements, if anyone is not aware, are where a mother and a baby are accommodated together in a foster placement. And in this Medway case, it was quite a shocking case actually, where a young mother who also had learning disabilities was placed in a foster placement, and the foster carer made quite a few accusations about the mother over time, and it resulted in the mother being essentially asked to leave the placement and the baby remaining there. However, it later came out in court that the foster carer had been quite abusive and had actually made false allegations about the mother. And the mother had stayed in this placement and had put up with a lot of this treatment in order to remain with her child, and eventually had been separated. So this was a case that obviously was very unusual, but it really demonstrated how that mother and baby placement under Section 20 can create this situation where someone might feel a bit trapped and feel like they can't then withdraw their consent, because it would mean that their baby would be taken away rather than being able to stay with them. So another issue that comes under the kind of umbrella of consent is capacity. This is an area that's quite well covered actually in the case law. There's some really good guidance on it from the Voluntary case. And if anyone works in practice, this may well be in your kind of guidance documents. It was certainly in quite a few of the smaller FOI study that I've already done. This case was a case involving a mother with cognitive issues who had just given birth. She'd had a really difficult labour and then had to have life-saving surgery, and was then also on really strong painkillers, She'd already said no to agreeing to Section 20 earlier in the day, and she later agreed while she was still in hospital on the same day, recovering from the birth and surgery. And the judge in that case gave some really thorough guidance on assessing capacity, what to consider, what questions to ask yourself as a social worker during that time. And so that guidance is quite kind of thorough. There's also a question though around Section 20 with newborn babies and when that is appropriate. So we've spoken about the Coventry case, and it was really questioned whether it was appropriate to really ask her on the same day when she was going to be recovering in hospital for a while. There were nurses around. There was no indication that the baby was specifically at risk during that time. So it could well have been left for a while to allow the mother to recover for a bit longer. And in some cases, judges have asked whether it's ever really appropriate to use Section 20 with newborn babies. However, in Re-M, which is just from this year actually, there was a demonstration of a really ideal use of Section 20 where a baby had been relinquished for adoption. And Section 20 was used as kind of a holding measure that during that time after the baby was born, to give the mother space and time to sit with her decision and become completely sure before the adoption process was started. So there are certainly cases where it is appropriate with newborn babies. So then finally, on the topic of consent, there is a question about informed consent. And so in Re-S, on the topic of capacity, again, it was said that parents must be able to understand, retain and weigh up the relevant information to the specific decision. So this was talking about using child-friendly language for really young parents or using interpreters for non-English speaking parents. But what's interesting here is that in this case, and again, no other case that I have come across, there is any real information about what is the relevant information surrounding Section 20. And in Williams and Hackney, again, the Supreme Court case, Lady Hale said that it's only good practice for parents to be given clear information about their rights and the local authority's responsibilities. So there is still a potential for a court to hold that consent is valid, even if those rights, like the right to remove the child or continue making decisions and exercising their PR while the child is accommodated, haven't been told to the parents. And as we talked about earlier with the legal advice, the access to legal advice and the problems there, this is further exacerbated because this could create many situations where parents really don't know their rights under the Act, and it can still be perfectly lawful for them to not be informed of them at all. So this again is another really kind of questionable and grey area where the law doesn't seem to be quite as clear or as robust. So then finally, to kind of check in where we are now and what could happen next, Williams and Hackney did seem to cause a bit of a calming down in the use of Section 20. It's kind of leveled out and it doesn't seem to have been quite a big cause and contention in case law anyway since that time. But as I've discussed and some other academics have said too, it doesn't completely clear things up and there's still definitely some questions hanging over from that case. And in general, there's still a kind of a lack of guidance and policy on Section 20. We've had some from CAFCAS in 2016 and from the Public Law Working Group in 2020, but these are only best practice recommendations and their implementation by local authorities seems to vary, or at least it did in my smaller FOI study. So that will be something that I'll be looking out for in the findings that I'll be looking at soon. But it definitely is something that doesn't seem to be kind of standard practice yet. And there's still a real lack of knowledge about Section 20's use, and the voices of those making the agreements haven't been heard. And unfortunately, and frustratingly, my research isn't going to remedy that, because although it was part of my plan to interview family members and social workers, it's something that I have not been able to reach those that I've needed to. So that's something that really still needs to be done, to be able to hear the voices of those who this actually affects in practice. Okay, so I'll move on to questions, and hopefully that wasn't too much information.
India, that was lovely. Thank you very much. And I think it's an absolutely fascinating topic, which highlights the risks of using Section 20, the dearth of practice knowledge about its use, the critique of the voluntary concept of this policy. And I think you've provided also some great practice examples that we can all really learn from. So thank you for your time today. We've had actually quite a lot of questions coming in. They're big ones as well. So I'm going to take you through them slowly. So I'm going to start with the first one. So brace yourself. I can repeat it if you need to. Only brace yourself because it's long. They're actually brilliant questions. So they said that I'm working on a case at the moment where it's increasingly likely that the local authority will take action to remove the children for their own safety. Mother has potentially agreed to a Section 20, but the father, who also has PR, is refusing. The parents are in the middle of separating and the father does not have capacity to care for the children. What do you think would happen in this situation? And I have to sort of put the caveat there that you're not a local authority solicitor at the moment and you can't be practicing and advising on practice in that way. But as a general overview, if you wanted to provide some points on that.
Yeah, so based on the case law, it is a really interesting situation, because specifically in the section of the Act, it does say that the person with parental responsibility has to be willing and able to care and accommodate the child. So it's a very difficult situation where if the father is saying no but can't actually accommodate the child himself, or provide alternative care for the child, then is that kind of objection valid? It's a very interesting question. I would wonder whether, kind of just to be on the safe side, it would make more sense to not use Section 20 in that situation, just because there is that question around consent. But it's very difficult. I as Tracy said, I have no idea how how that can actually be done in practice, but it's I think it's a perfect example of where Section 20 becomes problematic, where you've got consent from one but not the other. And yeah, sorry, I can't be of more practical help.
That's okay, thank you. It's a big one, and I think it's really worthwhile. You probably have already. I won't mention the name of who did it, who put the question in there, but it's a great question, great for us to discuss. But certainly have a chat with the local authority solicitor for further advice on that, because it is a challenge. The next question we have is, can you offer some insight into the use of Section 20 where parents with children with disabilities ask for help under Section 21C? The person, for example, the person's been prevented from providing care or accommodation, often due to stress, poor mental health, etc. Is there any research on how this operates in England with different local authorities, variants, trends, etc.? And then they've just added on there that children with disability are by definition children in need, and therefore how do local authorities respond to this with the rationing and the gatekeeping?
Yeah, so disability, again, I'm sorry to have to keep saying it is not my area of expertise. And it's kind of an opposite situation to the one that I'm looking at, where the family are the ones who are asking for Section 20 themselves, rather than being asked to agree to it. I am aware that there have been some problems where local authorities have not been as open or as willing to provide that accommodation in situations. where they've been asked to. However, as far as I know, it's a much more straightforward thing, because consent isn't an issue so much there, because if the parents themselves are asking for the accommodation and asking for help, generally there's not such a big question around whether it's voluntary, or whether a care proceeding is necessary in that situation. So in an ideal situation, that would be the best way that Section 20 can be used, really, and one of the really important uses that it was designed for. However, the issue could come up that if local authorities are not kind of as willing to provide as much help as is needed. But as I say, that's not really something that I know a whole lot about.
Lovely, thank you. I'm going to move to the next one because we've got a few more coming in too. The question is there any data or understanding of the use of Section 20 at the instigation of parents as a result of maybe child or adolescents, particularly parent violence?
There's not, as far as I have found and am aware, there is not much data at all about Section 20. We have the numbers that I gave on the slides in terms of how many children are coming into care or becoming looked after under Section 20. But within that, there's not really any breakdown as to the reasons and to the situation. So it's very hard to know how many of those are these kind of short break and more family support situations, or how many are much more child protection situations, how many are, as you're saying, older children and family breakdown issues where there might be violence, there might be problems between older children and still living in the same house as the parents. So it's really difficult to know, and this is another one of the problems with the lack of research that's been done, because we just have no idea.
That's great. There was I'm skipping a question, but I will come back to it. But I think tying into that, there was another question about wondering if there's any research on use of Section 20 in situations involving child criminal exploitation, child sexual exploitation, county lines, etc. But I would imagine it's kind of the same response.
Again, yeah, not that I'm aware of. There is very, very little done in terms of research on Section 20.
Going back then to the other question, how would we as professionals support a young person accommodated under Section 20 in regard to their mental health, particularly around their identity and sense of belonging? I did a year and looked after children, and there was such a high level of placement breakdown, and children and young people often had the label of being challenging, which meant there was no longer a suitable place for them. I know it's very practice-based. I'm not sure if you're comfortable answering that, but I'm going to present it to you anyway and see what you want to do with it.
I can give my kind of legal perspective on it. So I think largely a big question would depend on the age of the child, because over the age of 16, a lot more can be done with the child's permission themselves. So in terms of things like identity, medical care, mental health care, and the accommodation itself, a lot more of that can be agreed with the child without the need for parental permission. Whereas if a child is accommodated under Section 20 and under 16, and maybe, if we're talking about identity, maybe we're talking about going through gender identity issues or race or anything to do with that, it is still essentially up to the parents what is kind of done around those things, and whether they are happy with their child to be receiving particular therapies or medical care, if they are the only ones who are holding parental responsibility. So that's where problems can come up if parents are not consenting to those things. That's where the fact that the local authority doesn't have parental responsibility can become an issue.
Thank you. I've got two more at the moment. I don't know if more will come in, but one of them is it's a big one as well, and I'm hoping I'm going to get it right. So India, have you looked at the stats in SSDA 903 regarding entry to care for children who were previously looked after as young children, yet had been in permanence? In your freedom of information, did you refer to the stats for the last few years, which basically say that at least 200 children from, I think, special guardian homes and a further 200 from adoptive homes are approximately 2,000? And approximately 2,000 are voluntarily accommodated from previous permanence, but local authorities purport to not know what the previous placement was. There was additional case law in January this year, re the use of Section 20s versus care orders.
Yes, I know the case which was the last point there, which was a very interesting one. I didn't have time to go into it today, but it was initially going to be part of my talk. However, to do with the statistics, it's not something that I was aware of, and it's in my freedom of information requests are quite general. They're not specifically about different types of Section 20 or anything. They are basically just asking for any documents that local authorities use. So it's not something that I you have put any statistics or anything into, but they sound like really interesting, a really interesting kind of talking point. So I'd be interested to hear more or see the where that's come from, definitely.
Lovely, thank you. And as an IRO, an independent reviewing officer, I've come across a few occasions in the local authority I'm currently working in where the social worker has informed the family that if the parents did not agree to Section 20, the local authority may need to issue care proceedings. My view is that this would be an inappropriate use of Section 20. What would your view be?
Personally, I would agree. And from the case law as well, we can see that seems to be what the courts tend to agree with, that it shouldn't be used as kind of a threat or a way to coerce or persuade parents to agree if they don't want to. I think it's a really difficult one because without saying it, there is that kind of knowledge there anyway. So I can completely understand someone saying, well, just because I've said it out loud, does it make it any different? I think that's it would be an interesting kind of discussion point. But I do tend to err on the side of caution with things like that, or my opinion on things like that. So I would agree with you and say that it is probably not an appropriate way to go about making the agreement.
Wonderful. I think I don't have any more questions, but I did want to share that the case law referred to in the question before is in the chat if anybody wants to learn more about that. It's CA-2022-001329 and CA-2022-001232 for those who can't see the chat. Hopefully you can replay that a couple of times and it will make sense. It feels weird saying it just like that. The final comment I just wanted to share with you, Indy, because I think it's just a lovely comment instead of a question, is that they just wanted to say thank you so much. Your knowledge and confidence in this area really shone brightly throughout your presentation and really highlighted that Section 20 can be such a great area, which definitely needs more research. They've also shared that you might have given them ideas and a light bulb moment for an essay they're working on right now. So I think
lovely.
That is lovely.
Thank you.
And I also want to thank you. It's been a really interesting session today. And thank you everybody for your amazing questions and for engaging with this. And hopefully we'll see you at some future critical conversation webinars too. Thank you, everyone. Thanks, India.
Thanks, Tracy, and everyone.